Hello, 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 everyone. Come on in. I have a quick update regarding the case of the United States versus Sean P. Diddy Combs. Today is November 27th, 2024, and there has been a huge update in this case. For those of you who have been following, I haven't stayed in lockstep because I've been working on my other channel heavily. My content over there has been contenting, guys. So I do apologize. However, I thought that this was a monumental moment and a big update that I needed to come on and share with you guys. Today, in the case of the United States versus Sean P. Diddy Combs, Judge Arun Subramani has denied the defendant's motion for bail. In his response, he writes, Defendant Sean Combs renewed his motion for bail on November 8th, 2024. The court held a hearing on November 22nd, 2024, and the parties filed supplemental letters on November 25th and November 26th for the following reasons. Combs's motion is denied. No, number one, no condition or combination of conditions will reasonably assure the safety of the community. The court has, wait, let me cut this music, guys. There we go. The court has evaluated each of the factors that it must consider under 18 USC 3142G. 1. Nature and circumstances of the offense charged. 2. Weight of the evidence against the person. 3. History and characteristics of the person. And 4. Nature and seriousness of the danger that would be posed by the person's release. He goes on to cite a case. He says, see also United States versus Zezong. This case is back from 2022 in the Second Circuit. It says the courts have broad discretion in weighing the factors. The court has also reviewed the information submitted by Combs and the government across all three bail hearings in this case. He goes on to list all of the docket numbers in this letter, which identifies each argument from the defense as well as from Diddy's attorneys. Welcome, guys. Sean P. Diddy Combs has been denied bail, and I'm reading the judge's response. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of this finding, the court provides the following reasons. Number one, a rebuttal presumption of detention applies to this case. C 18 USC 3142 E3D. Even if Combs successfully rebuts this presumption, which the court assumes here, it remains one of the factors that the court considers in determining whether the government has met its burden of persuasion. Number two, the indictment the indictment charges Combs with serious and violent crimes. It alleges that for decades, Combs abused, threatened, and coerced women and others around him to fulfill his XXX desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engage in and attempted to engage in, among other crimes, XXX trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. It says that Combs himself carried out, carried or brandished pum-pums to intimidate and threaten others, including victims of and witnesses to his abuse. And notes that during searches of Combs's residence in March 2024, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as a drum magazine. When Combs's authority or reputation was threatened, the indictment alleges he and members of his enterprise engaged in acts of violence, threats of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence these acts of violence included kidnapping and arson. The indictment also charges Combs with XXX trafficking in violation of 18 USC 1591, requiring the court to consider the nature and circumstances of the offenses charged, including whether the offense is a crime of violence, whether it is a violation of Section 1591, and whether it involves a controlled substance or firearm. Number three, the government has presented direct evidence of Combs's violence. This includes video footage from 2016. There is clearly violence even in the version of the footage submitted by Combs, and text messages between Combs and victim one. Text messages from the hours and days following the 2016 Intercontinental Hotel incident. And it says, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. Then they redact out the other part of the message. Nevertheless, Combs argues that the weight of the evidence does not support a charge of XXX trafficking. In his view, it supports at best a toxic, sometimes violent, long-term relationship between Combs and victim number one. But regardless of whether that's true, there is compelling evidence of Combs's propensity for violence, requiring the court to consider the history and characteristics of the person. Number four, there is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had unexplained communications with witness one, who was subpoenaed to testify before the grand jury in June 2024, and in fact testified on July 25th, 2024. Combs was represented by counsel during this time, and they have offered an explanation for some of these communications. But they could not explain them all. For instance, Combs's efforts to call and text witness one, even after his grand jury testimony, or Combs's deleted texts with this witness. Although the phone records confirm that the defendant, using a particular phone number, and witness number one exchanged multiple text messages from June 2014 through, June 2024 through August 2024. There were no such messages recovered from Combs's cell phone associated with that number. Further, Combs's interactions with witness one are directly in conflict with defense counsel's representations to Judge Carter on September 18th, 2024, that Combs did not reach out to a grand jury witness and that he didn't do it and wouldn't do it. Number five, there is evidence that Combs violated Bureau of Prisons regulations during his pretrial detention to obscure his communications with third parties. He paid other inmates to use their phone access code, PAC, numbers to make calls to those not on his approved contact list. Instructed family members and defense counsel to add other people to three-way calls so that their communications were more difficult to trace. and used a messaging program called Contact Me ASAP, although the court recognizes that the parties dispute whether Contact Me ASAP is permitted or not. The government gives examples of Combs's communications utilizing these means from as recently as November 4th, 2024, directed to efforts to influence the jury pool or to reach out to potential witnesses. The court makes no determination that the content of Combs's communications through those channels was improper. However, his willingness to skirt BOP rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the significancy of any conditions of release, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. Describing Combs as a serial obstructor, that's what the government cited in their document, citing obstruction as a primarily primary reason for seeking detention, underscoring the court's concern despite defense counsel's assurances to the court at the November 22nd, 2024 hearing with Combs in attendance that Combs stopped using Contact Me ASAP as of November 16th, 2024. The government indicates that Combs has continued to use this service as recently as this past Sunday, November 24th, 2024. The number 6, the court further notes that it held an emergency hearing on November 19th, 2024 to address the government's usage of notes on legal pads recovered from Combs's bunk during a sweep of the Metropolitan Detention Center, MDC. At that hearing, defense counsel advised all these legal pads say legal. Yes, yes, they're marked as legal. That's what his defense presented at that hearing on November 19th. After the hearing, the court inquired why, in light of counsel's representation that the notes at issue were on legal pads that were clearly marked as legal. Photographs taken during the sweep show no such labels. At the November 22nd, the 2024 hearing, defense counsel admitted that it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. 1122, and he cites the docket as far as where the arguments came from. The circumstances of his indictment and the misrepresentations made at the November 19, 2024 hearing, where Combs was present, bear on whether the court can be reasonable, reasonably assured that any conditions it imposes will be followed, or whether through inadvertence or active subversion they will be broken and the community's safety threatened. Number 7, the court assumes that it may consider the bail package that Combs has proposed. But see the United States versus Bustani. He's citing another case, and it says here in parentheses, we now expressively hold that the Bail Reform Act does not permit a two-tiered bail system in which defendants of lesser means are detained pending trial while wealthy defendants are released to self-funded private jails. However, given the nature of the allegations in this case and the information provided by the government, the court doubts the significancy of any conditions that placed trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. He also cites here another case, the United States versus Orena. In parentheses, he adds it whenever it's in parentheses after the case, that means this is coming from case law from that particular case. In parentheses, it says proposal at best elaborately replicates a wait a minute elaborately replicate a detention facility without the confidence of security, such as a facility instills citations omitted. The court observes that pretrial services reached the same conclusion, not noting at the November 22nd, 2024 hearing that the conditions are insufficient and that there are no conditions that could reasonably assure the safety of the community. Number 8, finally, the facts and circumstances here differ from those in Combs's principal cited authorities. In the United States versus Fox, that case was July 8th, Second Circuit, 2022. The Second Circuit recognized the case presented an extremely close call and that any loosening of conditions, or more compelling evidence presented by the government could well tip the balance in favor of pretrial detention. But in Fox, the Second Circuit did not address a risk of obstruction, and the government failed to engage with the proposed bail restrictions. In United States versus Jeffries, while the government raised danger, its principal concern with respect to defendant Michael Jeffries was flight. He had no criminal history. The alleged criminal conduct, which did not involve not involve the kind of violence or RICO allegations made here, abate nearly a decade ago, and Jeffries was 80 years old. So, and then he also goes into another point, section 2. Combs's motion for temporary release is denied. The court also finds that Combs has not shown that a temporary release from detention pursuant to 18 USC 3142 is warranted. Under this provision, a judicial officer may permit a temporary release of the person in custody of the United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Combs's application under 3142I is based on the conditions at MDC, which he says makes trial preparation impossible. But given Combs's access to counsel and documents, there was an issue with Combs receiving a laptop for the purposes of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery, the end of this year, and time left before trial, over 5 months. Combs has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes under USC 3142 or the Constitution. But the court will promptly address any issues that arises with respect to Combs's trial preparation, and if the circumstances materially change, he may renew his application under USC 3142I. The motion is denied. The clerk of court is respectfully directed to terminate docket number 60. It is so ordered, dated November 27th, 2024, New York, New York. The Honorable Judge Arun Subramanian. So, like I said, guys, I know I haven't been on in a while, but I wanted to hop on tonight to give you this quick update. I honestly felt that this was going to be the case. Um, Based on everything that has been happening. Now, side note, everyone, side note, there was an article published today in a newspaper. Let's see. There was an article today published in the newspaper, and y'all are not going to believe this. It says P. Diddy threatened to unalive staff and threw objects at them and punched them, prosecutors claim. Now, this is dated today, November 27th, 2024. It says the Southern District of New York prosecutors have levied fresh allegations against Sean P. Diddy Combs, as per a letter to Judge Arun Subramani. In it, they claim that the music tycoon, 55, currently in custody at Brooklyn's Metropolitan Detention Center without bail, directed physical aggression not only towards employees, but also within his romantic relations. As Diddy faces a May 2025 trial on charges including XXX trafficking and racketeering. His not guilty plea stands firm amid denials of any misconduct. Accusations are swirling around Diddy for purported witness tampering and violent actions, with prosecutors urging the judge to dismiss bail. The next hearing to compilate Sean Diddy Combs' bail application is imminent as he counts down the days until his day in court. Despite efforts by his legal team to secure his release through a $50 million bond, the opposition from prosecutors remains staunch, highlighting alleged witness interference and illicit communication methods employed during his time behind bars. To date, these attempts to grant Diddy bail have failed since his apprehension in September. A ruling on his bail by Subramanian is anticipated to arrive sometime this week, which the ruling is what I just read. I'm trying to get to where they accuse him of hitting people in jail. Hold on, guys. I'm trying to get to where prosecutors also highlighted instances. Okay. Instances where Diddy's alleged abuse extended to his staff, with reports stating they have been described they have described the defendant threatening to unalive them, throwing objects at them, and being struck, punched, and shoved by the defendant, and being and seeing him do the same to others. Another part of the correspondence, U.S. Attorney Damian Williams, along with his legal team, pointed out Diddy's pattern
Stop, Steve.
of his history of obstructive conduct. I'm still live. Of obstructive conduct in their response to his bail request. The defendant's history of obstructive conduct is part of and parcel to his decades long pattern of violence. Where is the part where they say that he's trying to hit the COs?
Then it's time for me to go.
That's the part. Oh, it is?
Yeah, so I need you to help me brush my teeth.
No problem, baby. I'll be right there. So he is essentially staying there. Diddy will be staying there until it's time, until he is actually released by, well, acquitted by a jury of his peers. Hey, Beyond Billy. Hey, Kelsey Rico. I like your name. Hey, Sherry K. Let's see. Beyond Billy says, do you know the people on the Diddy list? No, I'm really trying to like stay on top of things and focus. But like I said at the top of this live, I have been working on my other channel, which was my original channel that I started, and there has been like a lot going on over there. If you guys follow me over on my Medea page, you guys know. Oh, thank you so much, Cheryl K. Happy Thanksgiving to you as well. I hope you guys have a wonderful Thanksgiving with your family. I'm getting ready to get out of here because this was going to be just me presenting the denial of his bond, and I'll keep you guys posted on any other updates. Enjoy your holidays, guys. Sean P. Diddy Combs will be spending Thanksgiving at Brooklyn's Metropolitan Detention Center. Until next time.
So close to my mouth.